Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. I'm a level with you all. The decisions were very long this week, and it seems that everyone and their mothers were dissenting. God knows my mother was. Before we get to those cases, I am happy to report that the Fifth Circuit just vacated its published decision in Membrano-Rodriguez v. Garland, episode 202. Membrano basically held that non-citizens inadmissible under INA section 212A7 at the time that they sought admission were ineligible for adjustment of status even if they were subsequently paroled. Relatedly, Membrano suggested that if a non-citizen's period of parole ended, they were no longer paroled for purposes of adjustment of status. Neither I nor Ira, to be honest, really understood what the heck the Fifth Circuit was talking about or how they got there. But it's gone now. And Ira tells me that he was able to take it out of his next edition of his book just before the book went to print. So huge podcast congratulations to Paul Hunker, John Bray, and Robert Urenda on preventing a mandate from being issued in the decision and then getting the whole decision vacated. Seems like Oil agreed and helped out as well. Congrats to all. Here are the 7 cases that didn't get vacated this week. First up is Shen v. Garland, published by the Ninth Circuit on July 24th, 2024. This case is about credibility. Judge Miller dissented. Miss Shen is from China, came to the United States as a tourist in 2011, and overstayed the time permitted by her visa. Indeed, before the time even expired, she affirmatively applied for asylum with USCIS, claiming that she had been subjected to a forced abortion in China in 2003. And don't forget, thanks to Congress and the administration of Republican President George H.W. Bush, opposition to China's family planning policy can constitute an asylum qualifying political opinion by statute, as does someone who, quote, has been forced to abort a pregnancy or undergo involuntary sterilization, end quote. INA section 11842. USCIS did not adjudicate that application, though, which, to be honest, I think might violate the regulations, and instead, a few months later, placed Ms. Shen in removal proceedings for adjudication of the application. At an eventual merits hearing in 2015, Ms. Shen mistakenly said that her forced abortion occurred in 2011, but then immediately corrected herself to 2013, which also couldn't have been correct because she was in the United States, and then she corrected herself to 2003. She testified that Chinese officials were forcing her to terminate her premarital pregnancy before they'd give her a marriage license, and that her pregnancy was reported to local leaders. She was eventually restrained and forcefully provided an abortion. She later had an ectopic pregnancy, possibly as a result. On cross-examination, however, DHS counsel brought up its belief that in 2003, the Chinese government did away with required premarital checkups. It's not the clearest transcript, almost surely because Miss Shen was speaking through an interpreter, but it does seem that after some back and forth with the immigration judge, she conceded that this premarital checkup wasn't actually required and that she did it voluntarily. But still, the forced abortion, right? To summarize that transcript, believing there an inconsistency, quote, the IJ intervened, end quote, and pressed Miss Shen on this point, eventually stating, quote, I'll note for the record, Miss Shen appears to be crying, end quote, and using long pauses and such. The IJ now clearly believed Miss Shen inconsistent on the requirement of the checkup. Miss Shen eventually said this, quote, yes, I did contradict myself. I admit I have misspoken. Even it's up to now that it has been brought to my attention premarital checkup was done by a voluntary basis, not by force. About this matter, it happened in year 2003, and on top of that, I'm quite nervous today. I'm sorry, end quote. And again, she testified she was given a forced abortion. After taking the matter under advisement, the IJ found Miss Shen not credible. The IJ noted other reasons too. Miss Shen apparently lied about being married when she applied for her visa because a scumbag in China told her that she'd more likely succeed if she said in her application that she was married. And well, she did get the visa. The IJ also mentioned the confusion about the year of the abortion. Also, there were date issues with the household registration document, and quite frankly, her written asylum application was a bit different than her testimony regarding what happened at the premarital checkup. But whether the premarital checkup was indeed required or not seems to have played a significant role in the IJ's decision, albeit one of 5 stated reasons for adverse credibility. The BIA affirmed, but rejected some of the IJ's reasons, and that's pretty important. The BIA did not agree that the year of the abortion confusion or the kind of different story on the asylum application about the clerk was a proper basis for adverse credibility, as Miss Shen wasn't given a sufficient opportunity to explain the discrepancies. Nor did the BIA rely on the visa thing. After all, as the IJ also recognized, asylum seekers can be forgiven for lying to flee persecution. So that left only the date issue in the household registration document, and of course, this back and forth about whether Miss Shen really was required to go to that pre-marriage pregnancy checkup to get a marriage license. The Ninth Circuit remanded by split decision. Adverse credibility is always so case-specific, and I'll admit, this seems like a tough case. But here's what it really comes down to. At oral argument, the panel wanted to know when in fact this new policy of not having to go to the premarital checkup went into effect in China. Post-argument, and so post-briefing, Ms. Shen's attorney submitted evidence that the policy no longer requiring premarital checkups went into effect on October 1st, 2003, which is after all the events took place in this case. The Ninth Circuit then did its own independent research into foreign law and agreed. Quote, as a result, DHS's counsel's suggestion in cross-examination that the change had already taken effect by the time of Ms. Shen's checkup in January 2003 rested on a clear misstatement of the applicable Chinese law, end quote. As was the IJ's belief that Ms. Shen must not have been required to do it and so must be lying. The Ninth Circuit explained that it can essentially do its own research and take judicial notice of foreign law during the petition for review stage. And this is just me, but if the Ninth Circuit can do it, I bet the BIA and the IJ can too, should they desire. Lots of analysis as to why this is so relevant to us small folk, although counsel on the Fifth Circuit's Alejo Perez v. Garland decision from episode 199 and really all Fifth Circuit crimmigration practitioners should pique the discussion in this case about how after 1966, the federal rules of civil procedure and criminal procedure treat foreign law as a question of law and not a question of fact. Possibly relevant to the Fifth Circuit, given the court's belief in the Alejo Perez decision that state case law is more akin to issues of fact than issues of law for realistic probability purposes. But I digress heavily. Back to Ms. Shen, the majority goes on to argue with the dissent quite a bit about this foreign law consideration stuff and, of course, disagrees. Well argued, Oil. What about the fact that Ms. Shen didn't argue any of this before the IJ or the BIA? Well, first explain the Ninth Circuit, exhaustion of issues isn't jurisdictional after Santos Zachariah. It's a claims processing rule, albeit a mandatory one, if the opposing side raises it, which Oil did. Nevertheless, making a favorable ruling on exhaustion for those who are fighting against it, the Ninth Circuit held that, quote, the correct effective date of the Chinese law is a permissible sub-argument, enlarging on the issue that was properly exhausted before the agency, end quote. That is, Ms. Shen argued before the BIA that her premarital checkup was mandatory. This sufficed for exhaustion, even if she wasn't arguing Chinese law or dates. Ms. Shen also argued that from this mistaken assumption about whether premarital checkups were required in China at the time, all other adverse credibility findings followed. In any event, it's a pure issue of law, explained the majority. And based on that error, DHS clearly misstated Chinese law in its cross, and that quote in turn led the IJ to wrongly conclude that Ms. Shen became flustered after being confronted with information showing that her statement was false, end quote. But it wasn't false, explained the Ninth Circuit. She just became flustered. Now, Ms. Shen said some things and was clearly flustered again, but the majority has an explanation. Quote, even the most honest of persons might understandably panic on the witness stand in thinking that she had made a provable mistake in recalling events from 12 years earlier, and she might therefore immediately change her testimony on the ground that her memory simply must have been faulty, end quote. That's going in a brief, and should be remembered. That leaves only the dispute over the authenticity of that household registration document, but under the Ninth Circuit's en banc Elam decision, episode 72, credibility determinations are a totality of the circumstances analysis, and when one adverse credibility pillar falls, so too might the entire finding. That's what the Ninth Circuit believes might be the case here, given that there were only 2 adverse credibility reasons upheld by the BIA, so it remanded for further analysis. Plus, quote, the household register had little direct significance to Ms. Shen's asylum claim, end quote. Anyway, explained the court. Judge Miller isn't thrilled. But congratulations, Thomas J. Tirigo, for petitioner. And I never miss an opportunity to discuss cross-examination. Remember this case, as it provides ammunition to defend your client during the worst part of any litigator's life, cross-examination of your client. DHS will always want and quite frankly get latitude on cross-examination because it's cross, but they can't misstate the record in their cross-examination, and they can't just make stuff up to try to trick the respondent into being inconsistent. I don't think that's what happened here. I suspect DHS didn't know or didn't care about the month in 2003 that the law changed. But then again, quote, the DHS attorney plainly misstated the content of Chinese law in his questioning of Ms. Shen, end quote. And Ms. Shen's counsel could have shut this whole portion of cross-examination down had they had evidence of when the police actually ended this practice in China. Respondent's counsel is not powerless during cross-examination. It would have been pretty hard to be prepared for that niche issue on this cross, but bring your rule of evidence objections into removal proceedings and be prepared to use them when defending your client during cross. It could save everything. Need not wait to petition for review. And that is Shen v. Garland. Next is Colin-Villavicencio v. Garland, published by the Ninth Circuit on July 23, 2024. This case is about derivative citizenship and Convention Against Torture Protection, and it's another split decision, with Judge Fletcher dissenting. Miss Colin-Villavicencio was born in Mexico in 1983. She entered the United States using a border crossing card in 1988 at 5 years old, and in 1998, presumably when she was 15, her mother naturalized. Ms. Colin-Villavicencio filed her application to adjust to LPR status within a year of that, but missed her fingerprint appointment, and so, former INS denied her application as abandoned. And you know what? I bet you that no matter what's about to happen in this case, it's going to turn on that missed fingerprint appointment. Will Ms. Colin-Villavicencio be ordered removed because she missed a fingerprint appointment at 15 or 16 years old in 1998? The application was reopened, but she missed her fingerprint appointment again. She was placed in removal proceedings in 2002, and an immigration judge administratively closed the matter on the request of both parties. Admin closure's been around for a while, folks. Fast forward to 2015. Still not a lawful permanent resident, it seems, and Miss Colin-Villavicencio gets convicted of 2 counts of felony child abuse and some drug stuff. In recalendared proceedings, I would guess Miss Colin-Villavicencio represented herself and claimed she was a citizen due to her mother's naturalization when she was 15 years old. An IJ rejected the argument, and then pro se, it seems, Miss Colin-Villavicencio conceded that she was ineligible for everything except cat deferral, something that there's no way she really could have known. She feared criminal organizations due to her longtime residence in the United States, and IJ denied that too, and the BIA affirmed all of it. Pretty important stuff, though. If Miss Colin-Villavicencio is really a U.S. citizen, well, we as a country don't deport such people. For that reason, explains the Ninth Circuit, the issue need not be exhausted, that is, derivative citizenship, before the BIA, and the circuit can consider evidence outside the administrative record. Powerful stuff. Ninth Circuit going wild this week with its record and extra record review. The Ninth Circuit majority doesn't see a claim here. And actually, Miss Colin-Villavicencio, represented by counsel before the Ninth Circuit, didn't initially raise the citizenship claim at all. But the Ninth Circuit was being extra careful. Always complicated, of course. The derivative citizenship claim here is governed by the former sections of the INA, because the analysis always requires review of the statute in effect at the time that the act took place, in this case here, when the mother naturalized. At the time Miss Colin-Villavicencio's mother naturalized, the statute required a few things, but the first one that matters here is the element that the child was residing in the United States at the time of naturalization, quote, pursuant to a lawful admission for permanent residence, end quote, or, quote, thereafter began to reside permanently in the United States while under the age of 18 years, end quote. In 2008, the Ninth Circuit held that that statutory language required actual lawful permanent resident status by the child, something that some circuits require today, but others do not. Wild, right? You can get citizenship in one circuit, but not in another. And then even wilder. 3 years ago, in the en banc decision Cheneau v. Garland, episode 55, the Ninth Circuit overruled its 2008 precedent and held that strict LPR status for the child is not required. All that's required for this prong is that, quote, the child must have demonstrated an objective official manifestation of permanent residence, end quote. So the same person in the Ninth Circuit that wasn't a citizen for all those years can now be a citizen. Wild, right? Miss Colin-Villavicencio was totally residing in the United States permanently at the time her mom naturalized, but she didn't have LPR status, nor did she get it thereafter before 18 years old. That meant that when the IJ denied derivative citizenship in 2015, the IJ was correct under Ninth Circuit precedent, but not anymore. Now, Oyl argued before the Ninth Circuit that Miss Colin-Villavicencio, remember a child, didn't actually have the intent to reside here permanently because, as a child, she missed her fingerprint appointment and didn't seem to care all that much about her adjustment application as a child. I don't think the Ninth Circuit buys that. Quite frankly, I don't buy that, but Oyl's got to make its argument. The Ninth Circuit pivoted because actually, it's more complicated than that. An issue that it seems no party brought up before the Ninth Circuit, but it deemed dispositive. Miss Colin-Villavicencio's father never naturalized, and he was never married to Miss Colin-Villavicencio's mother. That means that under the former statute in effect at the time of the mother's naturalization, in addition to all that residing permanently in the United States stuff, to get derivative citizenship, Miss Colin-Villavicencio must show that, quote, the paternity of the child has not been established by legitimation, end quote. Which, too, is a bit wild because that weird requirement need not be shown if the parents marry and then divorce, and then the child goes to live with the mother. It's only if they never married. But it's required under the former statute again if the parents never marry. Miss Colin-Villavicencio couldn't meet it here. She knew who her father was, and more importantly, he knew her, and he had legitimized his paternity, explained the court. Punishment to the child for the father not being a deadbeat dad. Before going any further, Judge Fletcher in dissent argued that under the 2021 decision Guija v. Garland, episode 71, a common law or de facto union might cut it, which then I guess ends when there's a separation, so the whole legitimation thing wouldn't be relevant. But the majority said that Ms. Colin-Villavicencio never made that argument or presented that evidence, despite 2 rounds of supplemental argument, so it's waived. If you get a case that even sniffs of derivative citizenship, dive deep into the case law, the statute, the podcast case law page, and most importantly, Ira's book. This stuff is complicated and consequential. But anyway, the majority believed that there was never anything like a marriage, and the father's paternity was established by legitimation. Again, even though neither party was arguing for or against this issue, which really cuts against Ms. Colin-Villavicencio, who has the burden. She was born in Mexicali, Baja California, and so that area of Mexico's paternity law applies. Getting real deep here. Hats off to the Ninth Circuit law clerks. Under Baja California Code in 1983, a parent could establish parental rights by voluntarily acknowledging the child on the birth record before the civil registry officer. Other ways I bet too, but undiscussed, because the father's on the birth certificate with his signature. Paternity acknowledged. Again, a bit counterintuitively, under the old derivative citizenship law, this tanks Ms. Colin-Villavicencio's ability to get citizenship solely through her mother, where the parents were never married. In fact, it's often a moot point. BIA and circuit case law hold that when countries abolish, quote, the distinction between legitimate and illegitimate children, that suffices to meet the requirement of legitimation, end quote. The First Circuit BIA and I guess the Ninth Circuit have defined the term legitimation as, quote, the act of putting a child born out of wedlock in the same legal position as a child born in wedlock, end quote. And that seems to have been the case under Baja California Mexico's law in 1983. So there you go. Strange stuff indeed. The former derivative citizenship statute, quote, is silent about children with unmarried parents, a father who established paternity and a naturalized mother, end quote, which is what happened to Miss Colin-Villavicencio here, and it makes her not a citizen. So no, it wasn't because of the fingerprint appointment. Although if she had gone to it, maybe she could have naturalized long ago. This came down to the father having signed the birth certificate, and maybe just because Baja California had progressive family laws in 1983. Exceptionally long and complicated issue, and we've still got cat deferral. The Ninth Circuit affirmed denial fairly quickly. Yes, Miss Colin-Villavicencio's brother was stabbed by criminals 10 years ago, and she believes it's because of his U.S. ties, but that's not enough for many reasons. Cat deferral has many elements and a high evidentiary burden. And so, Ms. Colin-Villavicencio remains ordered removed. Judge Wallace concurred in full, but wrote to combat the dissent, which the majority did quite a bit as well. I already mentioned one of the main points of Judge Fletcher's dissent, which is 20 pages single-spaced, and so unfortunately will not be given the respect it is due. Judge Fletcher does, however, believe that the, quote, panel majority improperly acts as both a government advocate and a district court fact finder, and it approves an order of removal from the United States of a person who may well be an American citizen, end quote. All judges seem pretty amped up about this one, and for good reason. And that is Colin-Villavicencio v. Garland. Alright, we survived the Ninth Circuit's 2 novels this week. Next is Gonzalez-Rivas v. Garland, published by the 8th Circuit on July 23, 2024. This is an exceptionally short case about non-LPR cancellation of removal. Surely it was remanded because the 8th Circuit held that it lacked jurisdiction to review the BIA's determination that none of Mr. Gonzalez-Rivas' 3 U.S. citizen children would suffer for exceptional and extremely unusual hardship if he was removed, as non-LPR cancellation requires? After Wilkinson, circuits can review that, so long as the facts aren't in dispute, I suppose. And now, having reviewed the BIA's decision, the 8th Circuit affirmed the BIA. And yes, I remember this case. Episode 135. In addition to the hardship argument, counsel, who I know and who is excellent, argued as well that Mr. Gonzalez-Rivas, 1, quote, has a Fifth Amendment due process right to the care, custody, and control of his minor children, and 2, the BIA should shift to a best interests analysis that considers the adverse emotional and financial effects on children caused by the permanent separation of a removed parent, end quote. The Eighth Circuit reviewed that and rejected all three arguments pretty quickly. It held that the Fifth Amendment doesn't apply because denial of non-LPR cancellation doesn't require parent-child separation. The U.S. citizen children can go to Guatemala in this case with Mr. Gonzalez-Rivas, reasoned the Eighth Circuit. As to the best interest of the child argument, the Eighth Circuit dedicated one sentence, stating, quote, Mr. Gonzalez-Rivas has provided no authority allowing us to direct the BIA to implement a new analytical standard for determining whether an exceptional and extremely unusual hardship exists, end quote. No authority? Dare I say Loper Bright? Finally, reviewing the hardship determination, the court noted that the BIA properly considered all asserted hardships cumulatively, but deemed them lacking. Plus, jumping on Justice Sotomayor's dicta in Wilkinson, as we all knew would happen at the time, quote, application of the statutory exceptional and extremely unusual hardship standard is a mixed question of law and fact that is primarily factual, thus our review is deferential, end quote. And so, the Eighth Circuit again denied Mr. Gonzalez-Rivas' case. And that is Gonzalez-Rivas v. Garland. Moving right along to LN v. Garland, published by the Fifth Circuit on July 25th, 2024. This decision is about asylum and related relief. Judge Douglas concurred and dissented, in part, in this week of disagreements. And I'm sorry for singing at the beginning, but I just watched that Bob Marley movie, and I got a song in my heart now. Good movie. Miss LN, an acronym, is from Angola. She testified that two individuals murdered her father and members of her family in 1998 because her father opposed corruption and the Angolan government. As to Miss LN herself, well, in 2008, her home was shot up. In 2016, while living in Ecuador, two individuals dressed in Angolan clothing grabbed her hair and put a gun under her nose. Returning to Angola in 2017, her house was set on fire, and flyers were left outside her home that she believed related to her father's reporting of corruption 20 years earlier. She came to the United States for protection, but an immigration judge denied asylum and related relief and protection in a 17-page order, likely single-spaced. The BIA remanded, desiring more analysis of Miss LN's expert's testimony and about internal relocation. The IJ denied again, presumably this time more thoroughly. The BIA affirmed, as did a split Fifth Circuit. But not without a hard fight by Miss LN, which is thanks to Alyssa Steglick, co-director and clinical professor of the Immigration Clinic at the University of Texas School of Law. And as Alyssa messaged me, her clinical law students, Annie Fogel and Lizette Chan, who I guess are taking the bar right now. So although it was a loss, albeit a split one, a mid-summary congratulations to you law students and the clinic on a case well fought and convincing, at least one judge of the three. But a loss it was because two judges are greater than one. 4 arguments. Here we go. A bit hard though, given that the Fifth Circuit decided to just splice in facts throughout the analysis and not really tell the story of Miss LN, but it seems like the Angolan government kind of prosecuted the father's murderers, but not openly. I don't know. At base, the Fifth Circuit believes that the IJ's recounting of Miss LN's testimony and the other evidence relied upon was good enough here, and that the IJ and then the BIA's decision wasn't so bad as to mandate remand. Really, the majority doesn't want to reweigh evidence that the IJ said that it considered. As to the BIA's maybe not fully explaining its rationale that well, the majority sees it as the non-citizen's burden to convince, not the BIA's burden to address everything in a lengthy decision. The BIA must simply show that it gave, quote, meaningful consideration of the relevant substantial evidence supporting the non-citizen's claim, end quote. Done here, reasoned the majority. But there's your petition for review standard in the Fifth Circuit. I cannot stress enough how much the majority doesn't want to get into the facts, but instead the process, whether the IJ and BIA's decisions show that they did enough. The panel does get into the facts a bit more later, noting that while some evidence might not fully support the IJ and the BIA's decision, other evidence does. For example, Miss Ellen never identified who committed the murders, and so I guess might be considered speculating when she believes that those individuals had something to do with the later harm that befell her. Plus, those individuals were punished by the Angolan government, reason the majority, and thus undermining of relief and protection. The Fifth Circuit isn't willing to overturn the IJ on something as difficult to prove as whether an alleged persecutory government's secret trial shows that it was persecuting. This paragraph is telling of how difficult it can be to win asylum claims nowadays in certain circuits. Quote, "The BIA's conclusion, to be sure, is not the only possible conclusion on this record. The petitioner's evidence is that the government conducted trials in secrecy for crimes involving police or armed forces members, which may imply government involvement. On the other hand, factions in a government are not monolithic, and the secret trial could have indicated a rift between official factions. The only connection between the government and the murderers is by inference from the facts, that the trial was conducted in secret and the petitioner was not informed of the murderers' names." End quote. So reversal isn't required, reasoned the Fifth Circuit majority. But how do you disprove that? And Miss Ellen did have an expert after all. Also though, apparently the Angolan government did respond when she reported harm, and there were periods where she lived in Angola without any incidents occurring. Turning then to the cat claim, that, like past persecution to be honest in most circuits now, requires consideration of all evidence in the aggregate. Miss Ellen argued that the IJ and the BIA didn't do it. But here too, quite quickly, the Fifth Circuit just didn't see a claim. Not enough bad things actually shown particularized to Miss L.N. If you are left wanting from my summary factually, I believe it would be because, again, the Fifth Circuit really cloaked itself in standards of review. And Judge Douglas? Judge Douglas, in concurrence and dissent, did not so cloak. Mostly dissent. And LOL, I guess I'm not the only one left wanting. Quote, "Because the majority does not provide all the context underlying Miss Ellen's claims, we begin with a recitation of the full background." End quote. But this is a long episode with long cases, so unfortunately I can't do it. But it's a heck of a gruesome story spanning multiple countries. Really though, we get enough horror on this podcast. Just listen to Ira's interview from last week. As told by Judge Douglas, it's hard to see why the case was denied other than maybe that it's complicated and spanned many years. Well done, University of Texas Immigration Clinic again. It is true, as the dissent notes, that, quote, "each applicant for asylum relief deserves to have their claims heard and any subsequent denial of a petition adequately explained," end quote. If nothing else here, it appears that Miss Ellen had her story told and comprehensively litigated. And that is Ellen v. Garland. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Welcome back! Did you miss me? Next is Castillo v. Attorney General of the United States, published by the Third Circuit on July 24th, 2024. This case is about which circuit should a petition for review be filed in. Closely related to the recent BIA decisions about venue and choice of law, but not identical, which is exceptionally frustrating and confusing. Something the Third Circuit recognizes at the onset, quote, What has historically been a simple venue decision is complicated now by the reality that parties and judges and court offices can be widely separated geographically and still come together, virtually, for legal proceedings. End quote. Here's the gist. The NTA was filed with the Immigration Court in Cleveland, Ohio. The decision doesn't say where the hearing notices were issued from, but Mr. Castillo was detained at an ICE detention facility in Pennsylvania. Even more confusing, the IJ was sitting in the Richmond Immigration Adjudication Center, which, if I understand that correctly, is a building filled with immigration judges and attorney advisors that solely hears cases virtually and then decides them, and sometimes decides cases heard by other IJs sitting in other courts. But putting together the NTA, the physical location, and the IJ, that's the 6th Circuit, 3rd Circuit, and 4th Circuit. And between you and me, I waited until late on Friday to review this case because I thought it was going to be so boring and I just didn't want to do it, and it's so long. And I wasn't even going to do the underlying facts and issues. But how can I help myself? I was wrong. Mr. Castillo is from Mexico and, get this, was at one time a U.S. citizen, but he was denaturalized in federal court for his failure to disclose in his N-400 that at the time of his naturalization, there were criminal charges pending against him for sexually abusing his niece. He was convicted after naturalizing, and after denaturalization was detained and found removable for having been convicted of a crime of child abuse under INA Section 237A2EI. There is case law in at least 2 circuits now holding that at least aggravated felonies committed while someone's a non-citizen but convicted after naturalizing cannot make the individual removable after denaturalization because the aggravated felony removability statute at INA Section 237A2AIII only references, quote, aliens, end quote, convicted. So if the person is convicted as a U.S. citizen, not an alien, they can't be deemed removable under the plain text of the INA, and an old Supreme Court decision called Castillo, not Castillo, because they weren't aliens when convicted. And wouldn't you know it, Section 237A2EI uses similar language to A2AIII. It applies only to, quote, any alien who is convicted, end quote. Strong argument, then, that Mr. Castillo isn't removable, at least under the law of those 2 circuits. And wouldn't you know it, the 3rd Circuit is one of those circuits that has so held in the aggravated felony context. Singh v. Attorney General of the U.S., Episode 71. No wonder counsel wants to be in the 3rd Circuit, and for 3rd Circuit case law to apply, rather than the 6th or 4th Circuits. I'm not even reading the case at this point. What a case this is. The 11th Circuit is the other circuit, by the way, the Hilton decision from episode 49. The problem is that under the BIA's 2023 matter of Garcia, an even more recent matter of MNI decision, it's probably the Cleveland Immigration Court where the NTA was filed that has venue, meaning 6th Circuit case law applies. My God, DHS has so much power to choose their applicable law, should they desire going forward based on the issue at play, as they get to choose where to file the NTA with detained cases, where the IJ is sitting in a virtual adjudication center. Dare I say some DHS regulations or guidance should be issued, reining in what is at present seemingly very expansive power to file NTAs kind of wherever the DHS official wants to do it? And very important here as well, because this whole issue about where the conviction occurs where the person is a citizen and then they're denaturalized can still make a non-citizen removable under matter of Gonzalez-Rivas from the BIA in 2008, which, while not owed any deference, binds outside the 3rd and the 11th Circuits, although the 5th Circuit too, according to this decision. Okpala v. Whitaker from 2018. Just wow. The 3rd Circuit here held that the petition for review should have been filed in the 6th Circuit, and that 6th Circuit case law properly applies. Lesai. For petition for review purposes, venue lies in, quote, the Court of Appeals for the Judicial Circuit in which the immigration judge completed the proceedings, end quote. Doesn't really answer the question though, right? Heck, to me, that would seem to be the 4th Circuit, where the IJ was sitting. And there's a circuit split too, so it's all over the place. Check out footnote 6 and find your circuit. It's very confusing, and the Third Circuit does an in-depth analysis of what INA words mean. But at the end of the day, the court held pretty much the same thing as the BIA held in its similar issue of venue in matter of MNI. Venue lies and IJ proceedings are completed where the NTA was filed unless the IJ grants a change of venue. Take it from the court, not me. Quote, in the context of remote proceedings or hearings, the physical locations of the IJ and other participants are not what dictates the answer to the question of where proceedings occur. Instead, we agree with the First, Second, Seventh, and Ninth Circuits that proceedings take place in the immigration court in which the proceedings began, unless there is a formal change of venue. End quote. But by definition, that means the Third Circuit doesn't agree with the other circuits. Although petitioner's very knowledgeable counsel tells me that the Third Circuit may have misdescribed the circuit split just a bit. So it's all going back to the Sixth Circuit, which, to be fair, now means that the Sixth Circuit gets to decide whether to agree with the Third, Fifth, and 11th Circuits on whether people like Mr. Castillo are removable at all. And if they're textualists, they should, right? The Third Circuit didn't have to do this, but it decided to do it as a matter of equity, in the interest of justice. It sent the case to the Sixth Circuit. I bet I'll be doing this case again in about a year. Judge Porter concurred, and of course, the theme of this week, dissented, and got even more into the statutory weeds of appellate procedure. So, Mr. Castillo gets to argue in the Sixth Circuit whether his case is like Mr. Costello's, such that he's not removable. Can't wait. One more thing. Counsel informs me that while the NTA was filed in Cleveland, the hearing notices reflected the Moshannon Detention Center in Pennsylvania. The decision doesn't say this, but if that's true, and I have no reason to believe it's not, that would seem to directly implicate an issue that I believe was left open by the BIA in matter of MNI, and certainly matter of Garcia. What happens when the NTA was filed with one court, but EOIR itself is saying that the hearing location is in another, in its notices of hearing? The more questions answered on venue, the more questions created. And that is Castillo v. Attorney General of the United States. Moving on to Sandoval-Reynoso v. Garland, published by the Seventh Circuit on July 23, 2024. This case is about non-LPR cancellation of removal, but really it's about jurisdiction. Notwithstanding Wilkinson, the Seventh Circuit believes that it lacks authority to hear this case. Can't wait to learn why. Gonna cut to the chase. Mr. Sandoval applied for non-LPR cancellation removal, but an IJ and the BIA denied, finding that he had failed to establish his 10 years of continuous physical presence in the United States, and that he had failed to establish that at least one of his 4 United States citizen children would suffer exceptional or extremely unusual hardship if he was removed. Both necessary elements for the relief. On the 10 years, though, although Mr. Sandoval first entered the United States in 1999, it appears, he was voluntarily returned to Mexico, unsure what that means, 4 times between 1999 and 2003. I guess the IJ concluded that it was unclear where Mr. Sandoval-Reynoso was residing during that time, particularly as the NTA was served in 2012. And I see. The IJ also denied relief as a matter of discretion. Multiple attempts and actual illegal reentries, a DUI conviction, and some other factors outweighed Mr. Sandoval-Reynoso's equities, reasoned the IJ. And to the Seventh Circuit, Mr. Sandoval-Reynoso has a Patel problem. Heck, even after Wilkinson, explaining the jurisdictional stripping provision at INA Section 242A2B, the Supreme Court held that, quote, even if the IJ decides a non-citizen is eligible for cancellation of removal, is Step 2 discretionary determination on whether or not to grant cancellation of removal in the particular case is not reviewable as a question of law, end quote. And that's really the end of it, unfortunately for you, loyal listeners. Quote, as the IJ's discretionary decision controls the outcome of Mr. Sandoval-Reynoso's application, we need not consider his remaining claims about continuous physical presence and exceptional and extremely unusual hardship, end quote. even if the IJ misapplied the hardship standard, or indeed, even misapplied the BIA's discretionary framework. I would think the Seventh Circuit reads Supreme Court precedent as holding that it cannot review the issue. And they're probably right. Although keep arguing that discretion has a legal framework. Some court might bite. But Mr. Sandoval-Reynoso remains ordered removed to Mexico, notwithstanding his 4 U.S. citizen children. And that is Sandoval-Reynoso v. Garland. And so we conclude our week's case law journey with El-Gabali v. Garland, published by the Sixth Circuit on July 23, 2024. This case is long, and it's about I-751 waivers, something we rarely discuss on the podcast. It's also about motions to reopen and pro se non-citizens, something that we discuss often on the podcast. Miss El-Gabali is from Egypt and became a conditional lawful permanent resident after marrying U.S. citizen Mr. Muhammad in 2007. She became a conditional LPR rather than a full-fledged one because they had been married for a short amount of time when Mr. Muhammad petitioned for her, meaning that they needed to jointly petition to remove the condition a few months before the second year that the conditional residency expired. Seems like that Miss El-Gabali was granted an immigrant visa abroad and came to the United States. And the couple did timely file that joint petition. But unadjudicated almost a year later, Mr. Muhammad then withdrew the petition, meaning that USCIS considered Miss El-Gabali's conditional status terminated, and Miss El-Gabali was placed in removal proceedings, where she was in trouble, because now she had no petition for the IJ to review de novo. It was withdrawn. The only one pending was withdrawn before USCIS, remember? But Miss El-Gabali took action, and during the first continuance, filed 2 new petitions with USCIS, as the law allows her to do. The first was an I-751 petition request for a waiver to the joint filing requirement based on the fact that she had entered into a marriage in good faith, but that the couple had simply divorced. The second was that she had entered the marriage in good faith, but she was battered or subjected to extreme cruelty during the marriage. But USCIS denied both I-751 waivers based on a finding that the first element required of both was not met. USCIS didn't believe that Miss El-Gabali entered the marriage in good faith. Now that USCIS had ruled, though, the IJ could review those denials de novo. By the way, we're nearly 8 years into removal proceedings at this point. All pro se. Lots of evidence and testimony was provided, including from Mr. Muhammad himself, it appears. Seems that Mr. Muhammad's employer was Miss El-Gabali's brother-in-law, and that his wife, Miss El-Gabali's sister, had helped arrange the marriage that brought Miss El-Gabali to the United States. Honestly, it seems like detailed testimony from multiple individuals was had, and while it's not how I would choose to marry someone, this whole thing might not be so unique in Mr. Muhammad and Miss El-Gabali's culture. That being said, apparently, quote, the witness's testimony describing Miss El-Gabali's time in the United States and her subsequent married life with Mr. Muhammad differed significantly, end quote. Apparently, Mr. Muhammad contradicted some of the testimony that was had by other witnesses as well. And there were no real corroborating documents to support the claim that Miss El-Gabali and Mr. Muhammad lived together while in the United States. Plus, Mr. Muhammad testified that the couple never lived together as a married couple and were never intimate, and, quote, testified before the IJ that he believed Miss El-Gabali had married him to become an American citizen, end quote. How it came to be that such a witness testified in removal proceedings, unimpeached it would appear, is beyond me. The importance of having an attorney in removal proceedings. And I mean, after all that, the IJ found Miss El-Gabali not credible and denied both I-751 waivers. The BIA affirmed. Only then did Miss El-Gabali find an attorney who filed a motion to reopen. With that motion, counsel included a detailed statement containing the testimony that Miss El-Gabali would have provided if she had had an attorney below. The motion to reopen also included photographs of text messages with Mr. Muhammad and documents explaining Egyptian religious and cultural practices related to marriage, presumably to show that it wasn't so crazy what happened between Mr. Muhammad and Miss El-Gabali. Miss El-Gabali's statement also explained how her first husband's family in Egypt might harm her, given the fact that she brought her son from that first marriage to the United States and permitted him to marry a woman who practiced Shia Islam rather than Sunni Islam. What a mess. The BIA denied reopening, and it appears that counsel timely petitioned for review the BIA's first decision as well. Unclear. But both the denial of the case in chief and the denial of the motion to reopen are now before the Sixth Circuit. Let's do the case in chief first. Although the IJ's and certainly the BIA's credibility findings were, quote, cursory, end quote, the Sixth Circuit isn't quite sure that it can review it at all, given the underlying waiver at issue. But even if it could, it didn't believe the IJ's credibility determination so cursory as to prevent meaningful review. To the court, the IJ highlighted and explained the inconsistencies sufficient to withstand circuit review. Maybe the IJ failed to consider factors that support a credibility finding, as Ms. Al-Gabali argued, and maybe not. The Sixth Circuit isn't overly concerned, as an IJ need not explain every detail or their reasoning when doing a credibility analysis. At base then, the Sixth Circuit actually saw this as a factual dispute, not a legal one, which in the context of an I-751 waiver, it held that it lacked jurisdiction to review. Long way to get to not reviewing. And with that adverse credibility finding affirmed, or at least not reviewed, it's going to be hard to show that nonetheless the IJ erred in finding that the marriage wasn't entered into in good faith. Worse still, the Sixth Circuit saw a lack of evidence. Quote, other than Ms. El-Gabali's driver's license listing Mr. Muhammad's home address as her address, Ms. El-Gabali submitted no corroborating documents to support her testimony that she lived with Mr. Muhammad during the marriage. End quote. Other problems too. And while irrelevant given the marriage finding, the Sixth Circuit summarily explained that it did not see an extreme cruelty case either. Ms. El-Gabali also argued that the IJ failed to develop the record such that proceedings were fundamentally fair. Remember, she was pro se at the time after all, and in the Sixth Circuit, due process mandates that, quote, immigration judges be bound by the recognized duty to help pro se parties develop the record, end quote. The court just saw the IJ of having done so here, taking the lead, eliciting questions, and even providing Ms. El-Gabali's adult son an opportunity to ask questions. And the IJ's questions were open-ended, not leading. In fact, quote, the IJ in this case dutifully developed the record over almost 300 pages of testimony, end quote. The Sixth Circuit is quite content with the IJ's work. Turning then to the motion to reopen. Ms. El-Gabali's attempt, with the assistance of an attorney, to provide some of the very evidence deemed lacking by the IJ. Well, first off, tough standard of review, abuse of discretion. Plus, motions to reopen must present previously unavailable material evidence that establishes a prima facie case for the relief sought. Taking it one by one then, the Sixth Circuit believed that the photos of text messages were previously available. As to the statement of fear of returning to Egypt, it appears that Ms. El-Gabali told the IJ below that actually she had no fear of returning to Egypt. Now, Ms. El-Gabali argued that, consistent with recent precedent in other circuits, this stuff wasn't really available to her because she was pro se. Unsure what the deeper basis for that argument was, but I'm sure it was argued given the attorney on the case. Anyway, the Sixth Circuit rejected the argument. Nor did the Sixth Circuit believe that evidence was material such that, quote, it was likely to change the result of the case, end quote. Too many things supported a finding that the marriage wasn't entered into in good faith, to paraphrase the Sixth Circuit. And boy, oh boy, the Sixth Circuit really did save the best for last in this decision without even hinting at it until the very last page. If you haven't listened to my interview with Ira, go listen to it, because here we go, quote, finally, Ms. El-Gabali mounts a constitutional challenge to the structure of immigration court proceedings. Specifically, she points us to the Supreme Court case SEC v. Jarkessi, which considered whether specific administrative proceedings violated the Seventh Amendment's right to a jury trial in suits at common law. End quote. Way to quickly amend your papers with a 28J letter, counsel. Actually, it seems that the argument was made below, while Jarkessi was pending before the Supreme Court. In Jarkessi, the Supreme Court ultimately held that because SEC enforcement proceedings, quote, affected the private rights of defendants, adjudication could not be removed from an Article III court, end quote, where the civil defendants can then get a jury trial. With immigration, in contrast, though, explained the Sixth Circuit, but also the Supreme Court, kind of. Quote, initial adjudications of public rights could be conducted by the executive branch, end quote. Restated without the legalese, arguments over money with the SEC are more constitutionally significant than is whether someone gets to remain in the United States. As such, Jarkessi did not reason the Sixth Circuit literally destroy the entire immigration court system and administrative state. But some cases are pending that might next term or the term after. And Miss El-Gabali remains ordered removed. My goodness. And that is El-Gabali v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.